Hello, everyone, and welcome to today's webinar, What to Expect in 2024, a highlight reel. I don't know about all of you, but I cannot believe it is already December 12th. This year flew by. There were tons of legal updates. Our Policy Smart Handbook solution was updated over 450 times in 2023, and we already have 60 new policies with effective dates lined up for 2024. In a couple of weeks, it'll be January 2024, and here we go again. For many of you, it's handbook season again. What's new? When does it take effect? And what do I need to do? There's a lot to think about, and we will help you get started in the right direction. So don't panic, stay calm. We have a panel of Littler experts who will provide 2023 highlight recap, as well as insight into what to expect ahead in 2024. These experts are part of Littler's knowledge management team, and they are in constant pursuit of the ever-changing employment laws and regulatory updates. Before getting into today's presentation material, I'd like to introduce myself and my company. I'm Michael Worth. I'm the Vice President of Sales from ComplianceHR, and I'd like to thank all of you for joining us today at your very, very busy year end. I'm always pleased to see how many compliance clients attend our webinars. Thank you for being our client, and thank you for all the great feedback you give us to help make our solutions even better. Now, we have a lot of people still coming in here. I can just see that the attendance is ticking up at an amazing rate. We're already up to about 2,500 attendees. We had over 5,000 people sign up for this event. So I want to thank the entire audience for making this truly a blockbuster webinar. So all of you know who Littler Mendelsohn is, the world's largest employment law firm with over 1,800 attorneys and more than 100 offices in 28 countries around the world. Littler only practices employment law, and they are continually recognized as an innovation leader. So for those of you who don't know about ComplianceHR, we are a unique combination of a technology platform called Neota and Littler. There's no Googling or guessing. Users quickly receive accurate, up-to-date information regarding employment law. Our goal is to simplify the complexity of employment law. And we do that by offering a suite of technology solutions around independent contractor classification, handbook creation and updates, overtime, onboarding, and much, much more. Many of these topics will be discussed during today's webinar and can be resolved using the Navigator suite. So if you're interested in learning more about ComplianceHR, the easiest way is to say yes to the poll that will be coming up right now. If you're in full screen mode, you might need to hop out of that so you can see the poll, and simply click yes to the poll, and you'll be contacted by one of our experts who will meet with you and really try to understand your compliance strategies and how ComplianceHR can help support them. So there's a couple different ways. You can click on the poll that we have right now. There's a link for a demo and free trial, or you can just simply ask in the Q&A window. Okay, with all that being said, I would now like to turn it over to Littler and our content host, Meghann. Sorry, I forgot where I was. Meghann, what do you have lined up for us?
Thanks, Michael. I am happy to serve as the moderator for today's panel. I am, as Michael mentioned, I am with Littler. I am a Knowledge Management Counsel and Director of KM Projects. Since there is so much to cover today, I'm going to try to do as little speaking as possible and leave most of the substantive coverage to my fellow presenters. All of my fellow speakers today, like myself, work within Littler's Knowledge Management Department. One of our primary roles within Littler is to watch legal trends, follow legislation and case law, and support our clients and Littler attorneys in keeping up with the many compliance issues that come your way. Today's approach is really going to be rapid fire. We won't have time to cover everything today that's coming up in 2024, but what we've tried to do is compile many of the trending topics and the more quicker moving areas in labor and employment. So today's really more like a highlight reel. Because of that, we're not going to be able to go deep into any particular topic. However, we just wanted to cover as much as possible. However, if you do have any follow-up questions, please do place them in the chat. And then if we don't have time to get to them today, we'll follow up after the webinar. So our agenda today is as follows. We have Maureen Lavery, who will be discussing new legislation and anticipated legal trends, which includes AI, pay transparency, non-competes, and captive audience. Hannah Stilley will then talk about reproductive rights after Dobbs and how those laws will continue to impact employers in 2024. Michelle Devlin will then speak about how some of the major NLRB decisions and precedents will impact both union and also non-union workforces in 2024. Michelle will also discuss the ever-evolving and changing landscape of Me Too laws across the country. Finally, Amy Mendenhall will discuss handbook updates and what you need to do to get ready for the new year. Before we get started, with our main speakers, I did want to make a brief mention of a somewhat larger topic that we won't be covering in depth today, and that's because it's been covered in a past ComplianceHR webinar back in September by Littler shareholders David Jordan and Libby Henninger. In the summer of this year, the DOL announced their proposal to substantially increase the minimum salary level needed to qualify as exempt. The basics include increasing the current salary level to the 35th percentile in the lowest census region. Now, by the time the rule is finalized, which we're not exactly sure when that's going to happen, but we anticipate that to be in the first quarter of 2024, that could be as high as $1,558 per week or $60,209 annualized. That's an increase from the current annualized salary of $35,568. The other major change is that the highly compensated employee exemption is anticipated to increase to the current level to 85th percentile of the nationwide average. And those automatic increases are expected to increase at the same levels, the 35th and the 85th percentile, every 3 years. There is no change that is proposed to the duties test. Now, while we don't know the future of the rule because it will likely be subject to litigation once it is finalized, in that webinar that I mentioned, Libby and David do go over some items that employers can do now to prepare. So it would be a really good idea to check that out if you're interested. We'll throw a link in to the webinar in the chat. So up first, we have our first topic, new legislation and anticipated trends for 2024. Maureen Lavery is our first speaker. Before I hand it over to Maureen, I just wanted to share a little bit about her work. Maureen is a key contributor to many of Littler client resources, and she provides analysis of recently enacted statutes and regulations. She also monitors federal, state, and local pending legislation and manages many of our 50-state surveys covering various topics. So she is very familiar with the goings-on at all levels of legislation and regulation. All right, Maureen, I'm going to hand the mic over to you.
Meghann. Hi, everyone. Before I touch on our four main big legislative stories for 2023, which are the use of artificial intelligence in personnel decisions, pay transparency, regulation of non-competition agreements, and captive audience meetings, I'm just going to briefly talk about a couple of other topics that were big in 2023, just so you don't think that it's only those four things that you need to worry about. In addition to those topics of interest from the last year, we also saw a lot of states looking at their child labor regulations and in some cases making child labor regulation less onerous. A few new states enacted new paid family and medical leave statutes, and several states enhanced their anti-discrimination statutes by creating new protections prohibiting discrimination on the basis of a person's sexual orientation and gender identity. And also, I can't let this moment go by without talking about our, favorite topic, COVID-19. And interestingly, unlike in 2022, in which about a quarter of all enacted legislation concerned the pandemic, COVID-19 was not the legislative priority this year that it was in 2021 and 2022, although a couple of states did put up some regulations around workplace vaccination mandates. Diving into AI, I'll give you a super elevator speech version of what we're talking about when we're talking about AI. So there are two main types that are being regulated, and that's generative AI, or Gen AI, and predictive AI. Generative AI is what you think of when you're talking about ChatGPT, and it generates new material like literature, graphics, and music, or it can provide assistance with drafting written professional and academic material. Predictive AI makes predictions, recommendations, and decisions using various AI and machine learning techniques. And this is generally what we're referring to when we talk about using AI tools to assess job applicants and measure employee performance. So only a very small handful of jurisdictions in the U.S. have passed laws regulating the use of AI tools in employment decision-making, and that's Illinois, Maryland, and New York City. And New York City's ordinance was the first significant law in the U.S. that broadly regulates an employer's use of automated employment decision-making tools. And the ordinance requires employers to provide advance notice to candidates and employees if a tool will be used. And it also requires an employer to conduct an annual bias audit of any AI tools used and make a summary of the results of the bias audit public. However, the law does not require any specific actions to be taken based on the results of the bias audit. However, an employer still needs to keep in mind all the relevant federal, state, and local anti-discrimination laws that could apply to determine any necessary proactive actions based on the results of the audit. The Illinois and Maryland laws are very similar, and they both concern the use of a tool to assess a candidate during an interview. So the Illinois Artificial Intelligence Video Interview Act provides that employers using an AI-powered video interview platform must provide notice to an applicant and get the applicant's consent prior to using the tool. Maryland's law prohibits employers from using a facial recognition service to create a facial template during an applicant's interview unless the applicant consents. However, neither one of those states' laws requires an employer to provide an alternative interview format for an applicant who does not consent. However, an employer still needs to be mindful of the federal EEOC guidance on conducting interviews in compliance with federal anti-discrimination laws. In October 2023, President Biden issued an an executive order on the use of artificial intelligence. And among other things, it requires the Department of Labor to develop principles and best practices to mitigate the harms and maximize the benefits of AI for workers by addressing topics such as job displacement, labor standards, workplace equity, health and safety, and data collection. And once these best practices are identified, federal agencies are expected to adopt the guidelines in their own programs. The EO also requires the Department of Labor to issue guidance emphasizing that employers must ensure that employees are appropriately compensated for all hours worked under the Fair Labor Standards Act when using AI tools to monitor employees' work. In California, Governor Newsom also issued an executive order quite similar to the one that was issued on the federal level. And this one directs state agencies and key stakeholders to proactively assess for algorithmic discrimination, such as gender, racial, and other biases in high-impact areas, including employment decisions, and specifically mentions employment as an area of risk. On the legislation side, I think in 2024, we're probably going to see that states might be more inclined to follow the federal government, California, and other states that have created task forces or working groups to explore these issues around AI and predictive AI and develop frameworks for future legislation. A few states, including Massachusetts, New Jersey, New York, Vermont, and the District of Columbia, have bills still pending from 2023 that could carry over, so we could see some regulation in this area in the next year. Pay transparency. So in 2023, nearly a quarter of U.S. states introduced legislation around pay transparency, and that means laws that require an employer to disclose the rate of pay or a salary range in any job posting or advertisement for a vacant position, and sometimes to current employees when openings for a promotional opportunity. In 2023, we saw the most legislation yet on this topic of any year. Hawaii and Illinois both enacted new laws. In Illinois, employers have to disclose in every job posting a pay scale for the position and a description of the benefits and other compensation. And the requirement applies to job postings by employers with 15 or more employees in Illinois, and also applies to positions located outside of the state where the work could nonetheless be performed at least in part in Illinois, as well as positions where the employees report to a supervisor office or other work site that is in Illinois. In Hawaii, the employer must disclose an hourly rate or salary range that reasonably reflects the actual expected compensation for the position. However, Hawaii's law does not apply to job listings for positions with employers that have fewer than 50 employees, or positions that are internal transfers or promotions for a current employee. Colorado had enacted a pay transparency law previously, and so did New York. However, those states both enacted amendments to their pay transparency laws in 2023. In Colorado, the original pay transparency provisions required employers to disclose the pay range for a job position in each advertisement for a job opening. And an employer is required to notify the colleagues of each new hire or promotion of the identity of the candidate and provide information on how employees may demonstrate interest in similar job opportunities in the future. The amendments in 2023 to Colorado's law primarily focused on disclosures to current employees. And if a posted position has a defined quote-unquote career progression, employers have to disclose and make available to all eligible employees the requirements for the career progression, along with each position's terms of compensation, benefits, whether it's full or part-time, job duties, and information on access to further advancement. The 2023 amendments also require an employer to internally announce new hires and promotions to the employees with whom the selected candidate will work. So quite a significant level of regulation there in Colorado. In New York, their pay transparency law was originally enacted last year in December 2022, so about a year ago. And this year, the state worked quickly to amend the statute to clarify which positions require an employer to disclose the compensation range. As originally enacted, the law required employers advertise a job promotion or transfer opportunity that can or will be performed, at least in part, in New York. But the 2023 amendments clarify that the pay range disclosure requirement applies to jobs that will be physically performed in whole or in part in New York. And moreover, the amendments make the disclosure requirement applicable to positions where the work will not be physically performed in New York, but the position would report to a supervisor, worksite, or office that is located inside of New York. And in the last few weeks, we've seen that the Massachusetts legislature, as well as the District of Columbia City Council, have basically finalized their pay transparency bills. A few more details to be worked out, but I think that we may see those getting enacted in 2024. Also in 2024, I think we can be reasonably certain that the jurisdictions whose 2023 bills didn't pass will reintroduce their legislation and try to get it passed. Non-competes were another big topic this last year. On the federal level, restrictions on non-competition agreements are part of the pro-worker legislative priorities of the Biden administration, but it's uncertain whether any concrete action will occur at the federal level. California has restricted non-competition agreements for a really long time. However, this year, the state enacted 2 separate bills that created additional restrictions around non-compete agreements. Senate Bill 699 expands the reach of the non-compete restrictions and provides that an employment contract that is void under California law is also unenforceable regardless of when and where the contract was signed. And Assembly Bill 1076, which was enacted in October, clarifies that the state's non-competition law must be broadly applied to void any non-compete clause or agreement, no matter how reasonably tailored, that does not satisfy one of the exceptions that are stated in the statute. And most importantly for employers, Assembly Bill 1076 requires that by February 14th of next year, employers have to provide written notice to current and former employees employed after January 1st of 2022, whose contracts include a non-compete clause or who were required to enter a non-compete agreement that does not meet the statutory exception that the clause or agreement is void. We also saw Maryland and Minnesota enact restrictions around non-competition agreements this last year. And I think in 2024, we can expect to see more states start to introduce legislation that limits an employer's ability to require employees to enter into a non-compete. Finally, let's talk about captive audience meetings. And this also concerns the broader topic of workplace freedom of speech. The captive audience laws regulate how an employer can lawfully convey messages to employees about religious and political matters, along with issues related to unionization. Some of these bills usually include the decision to join or support a labor organization within the definition of quote-unquote political matter. So these laws significantly limit what communications an employer can make to employees related to unionization. However, the laws don't entirely prevent an employer from conducting this type of meeting, but they do provide that an employer cannot require an employee to attend a meeting or retaliate against an employee for not attending a meeting at which an employer will communicate its opinion or position about religious and political matters. Montana enacted an interesting law this year, which is not quite a captive audience law. However, it still prohibits an employer from discriminating or retaliating against an employee because of the employee's political affiliation or because the employee is expressing political views. And other states that considered legislation that would prohibit political affiliation or political activity discrimination include Hawaii, Utah, Iowa, and Virginia. And I think in 2024, we should expect to see a lot more of these bills introduced. It's a hot button legislative issue, and I think it's going to be especially so next year since it's an election year. All right, that closes us out. I'll turn it right back over to Meghann so that we can start learning about our post-Dobbs landscape.
Thanks, Maureen. Next up we have Hannah Stilley to discuss how reproductive rights laws will continue to impact employers in 2024. Hannah's a legal research attorney in Littler Knowledge Management Department. She conducts research and analysis of employment laws, and she also assists with the drafting and editing of firm publications, including our 50-state surveys. Like Maureen, Hannah is deeply involved in the analysis of recently enacted statutes and regulations. So Hannah, I'm going to turn it over to you and so to see what you can tell us about reproductive rights laws next year.
Thanks, Meghann. Good afternoon, everyone. We're going to be talking about the legislative trends that have been observed since the Dobbs ruling that we expect to continue in 2024. In June 24th, 2022, the Supreme Court ruled that there is no federal right to abortion and the authority to regulate abortion was returned to the states. After the Dobbs decision was dropped, there were a few initial concerns from the public and employers. Abortion laws changed rapidly because there was confusion about what laws were in place. For example, these were due to bans that became enacted upon the reversal of Roe, or even old invalid laws from the 1800s or early 1900s that were technically still on the books that prohibited abortion. The validity of these laws are still being litigated today. Due to the rapidly changing abortion laws, many employers inquired about creating travel reimbursement benefit programs for their employees to obtain abortions in other states. There were concerns for civil and criminal liability from certain states like Texas, in which private groups and some state legislators who have threatened companies for their travel reimbursement programs. These initial concerns will likely continue to be a worry to employers in 2024. However, the effect of Dobbs covers much more than just abortion bans. The legislation that we are seeing includes reproductive health services and gender-affirming care. The definition of reproductive health services will be different depending on the specific law or jurisdiction. Common health services that we have been seeing included in the definitions of bills include abortion, choice to sustain a pregnancy, miscarriage, contraceptives or right to refuse contraceptives, sterilization, and assisted reproductive technology. Gender-affirming care is also included in many new bills to the interconnectedness to bodily autonomy and privacy. Common healthcare services included in bills for gender-affirming care include medical, psychological, and surgical services for transgender and non-binary individuals. However, cosmetic procedures are generally not covered. Littler's legislation team has been tracking federal, state, and local legislation regarding reproductive health services and gender-affirming care as they would affect employers. The chart below includes tracking on abortion bans related to gestational age and viability, employer liability, bills related to civil procedure, insurance coverage, discrimination, and much more. This tracking does not include restrictions that do not concern employers, such as targeted restrictions on abortion providers, otherwise known as trap laws, abortions or other restrictions for minors, or specific abortion medication prohibitions. Without such parameters, there would be thousands of bills to track. From January 2022 to December 2022, there were 72 tracked introduced bills. Out of those bills, 21 were enacted. An important caveat for these numbers is that when the Dobbs decision dropped, it was in the middle of the year. Some states had already adjourned their legislative sessions for the year, or it was a tail end of a legislative season. Therefore, a relatively lower number of introduced bills for this particular topic. However, some states had short special sessions at the end of the year and were prepared to legislate due to the Dobbs decision, hence the higher percentage of enacted bills from 2022. For 2023, these numbers include bills from January 1st, 2023 to December 1st, 2023. 348 bills have been introduced so far in this time range, and out of those bills, 48 were enacted. The bulk of the bills that have been introduced and have not passed a state's House or Senate committee. And even since December 1st, we have had multiple states introduce more reproductive health bills. Now we get to address the types of legislation that we have been seeing since the Dobbs decision and are likely to continue seeing in 2024. Before we get into the trends, it is important to point out that we are seeing reproductive health legislation being introduced in most states. However, the bulk of the enacted laws are coming from states that are restrictive on abortion and states that are protective of abortion. Keeping this in mind, please look at the map from the Guttmacher Institute that illustrates each state's restrictiveness and or protectiveness of abortion while we talk about the trends in reproductive health legislation. First, in 2023, we continue to see abortion bans go through the legislative process. These types of bans usually prohibited all abortions except in certain circumstances or banned abortion at a certain time period in the first trimester of pregnancy. In 2023, abortion bans passed in Florida, Iowa, Nebraska, North Carolina, North Dakota, South Dakota, and Wyoming. However, in Florida and Iowa, these bans are on hold while litigation is ongoing. On the opposite end of the spectrum, there were bills introduced regarding the expansion of reproductive health rights in general. In many states, multiple bills have been proposed for a constitutional amendment to amend the state's constitution to provide the right to reproductive freedom. And I will get into these ballot measures later on in the presentation. Another example is that Massachusetts passed a law that provided that access to reproductive health care services and gender-affirming care services is a right secured by the laws and Constitution of Massachusetts. Our next trend is something called a shield law. These came to be due to some states, such as Texas, that allow private citizens to file civil actions against individuals for receiving an abortion, to perform an abortion, or the aiding of abortions. The effect of these laws is that jurisdictions started passing shield laws to protect or, quote, shield their own residents or business entities from another state's laws that permit civil or criminal actions against an individual or a business entity where healthcare is lawful. These laws do not protect an individual if they receive healthcare that is illegal. Bills that we have seen include protections from extraditions, subpoenas that mandate a person to attend an out-of-state court proceeding, or out-of-state investigations. These bills are not just limited to abortion. Many include the term lawful protected healthcare activity that includes reproductive health and gender-affirming care. For example, Washington passed a law that the state will not surrender any persons that provide assistance to protected health care services, including reproductive health care and gender-affirming treatment. There have also been a substantial amount of bills introduced regarding mandatory health plan coverage of certain reproductive health treatments and services. A big portion of these bills that we have been seeing since Dobbs propose mandated coverage of certain contraceptives. Other bills include mandatory coverage of abortion, treatment or diagnosis of infertility, gender-affirmative care, and sterilization. For example, Vermont passed a law that requires health insurance plans to cover gender-affirming health care and abortion-related services. In D.C., group health benefit plans are now required to provide coverage for the diagnosis and treatment of infertility, including in vitro fertilization. Upcoming on January 1st, 2024, Montana will start to require insurance to cover fertility preservation services for individuals who are diagnosed with cancer. For our last trend, we have been seeing employment discrimination protections related to reproductive health decisions. Some bills have used the terms such as reproductive health autonomy or pregnancy outcomes and are best illustrated by enacted legislation from Cincinnati, Ohio, and the state of Michigan. In Cincinnati, employers are prohibited from discriminating against an individual due to their sexual or reproductive health decisions. Such decisions may include contraception, sterilization, fertility treatments, abortion, STIs, and medical treatments to affirm gender identity. Michigan's new law amends the state's Civil Rights Act to define pregnancy as including the termination of a pregnancy. Therefore, an employer cannot discriminate against an employee or applicant due to the person's choice to terminate or not to terminate a pregnancy. For my last slide, there are a few other considerations to take note of in the coming year. Ballot measures can come about through citizen-initiated or they can go through the state's legislative process depending on the state. There were 3 states in 2022 that passed such constitutional amendments: California, Michigan, and Vermont. And most recently, in November's election, Ohio constituents voted to establish a right to make and carry out an individual's own reproductive health decisions. However, at this time, it is going through the court system to repeal existing restrictions, and that means we are still in limbo to see how this new ballot measure will play out. Looking towards 2024, Maryland and New York both have proposed constitutional amendments to be voted on in the November 2024 elections. And we will definitely be seeing more of these efforts in the coming years. There are multiple potential measures that are pending signatures to be certified or in the final legislative process. Arizona, Arkansas, Colorado, Florida, Iowa, Missouri, Montana, Nebraska, Pennsylvania, and South Dakota are some of these states. I would like to lastly note that there will likely be continual challenges to these new laws, existing abortion bans, and ballot measures. At any point, a law could be blocked or ruled as unconstitutional or constitutional. Due to the rapidly changing nature of reproductive health, it is advisable to consult an attorney if there are questions about the legality of a reproductive health law. That is all that I have for you all today. Thank you so much. Back to you, Meghann.
Thanks, Hannah. That was fantastic. Our next 2 topics will be covered by KM counsel Michelle Devlin. Michelle is a former litigator focusing on labor management relations under the National Labor Relations Act, as well as in general employment litigation and compliance. As a KM attorney, Michelle supports a variety of practice groups, including our traditional labor group and our attorneys also who focus on separation agreements and mass layoffs. Michelle is going to first share with us how the NLRB decisions and precedents of late will impact not only union but also non-union employers, which might be a surprising takeaway for some webinar attendees. Take it away, Michelle.
Thanks, Meghann. Hi, everybody. Before our non-union employers thinking that this portion about the NLRB is not for them, let's do 2 quick polls. The first question, true or false, the National Labor Relations Act only applies to unionized employers. Is that true or false? Stephanie, if you could just let me know when that's closed out. All right, well, I'm glad to see that almost all of you were correct here, that is false. In fact, all employers in the private sector are subject to the NLRA with limited exceptions. And poll number 2, true or false, only unions and members of unions can file unfair labor practice, or you'll hear me call them ULP charges, with the National Labor Relations Board. True or false? Okay, so again, almost everyone was correct in answering that this is false. In fact, employees, unionized and non-unionized alike, have what are called Section 7 rights under the National Labor Relations Act. You'll hear me refer to Section 7 rights. And these are the rights to self-organization, to form, join, or assist labor organizations, unions, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, or to choose to not do these things, to refrain from them. That's from the statute, and we can call all of that protected concerted activity, or PCA, as you'll hear me call it. Now, we see a lot of media hype this year surrounding union organizing, high-profile corporate campaigns and strikes and deals made at the bargaining table. But the truth is that National Labor Relations Board activity slowed down this year as compared to the prior year. The board reported that the number of ULP charges filed with the board increased by 10% this fiscal year, but that was less than the 19% increase seen over from 21 to 22. Similarly, when it came to election representation petitions, there was a 3% increase this fiscal year. However, that was much less than the 53% increase that was seen from 21 to 22. So we could expect that going into 2024, will that continue to decline as employees may realize that they are not getting what they thought they were when it came to union organizing. All right, now, nevertheless, despite that slow, the NLRB and their general counsel, Jennifer Abruzzo, were extremely active this year and aggressive in their pro-union agenda, not making any bones about it. And we're going to talk about some of those major decisions that are going to affect both unionized and non-unionized employers in 2024. Now, firstly, there were many new legal rules put into place or about to take effect that make for easier union organizing. By the way, there are a lot of case names here. I'm not going to mention most of the case names, but if you're interested, just drop it in the chat. We can get you that information. On December 26th of this year, as a holiday present, we returned to what were called under the Obama administration the quickie or the ambush election rules. And as I said, effective December 26th, and these greatly shorten the timeline from petition to election by as much as a couple of weeks through shortening of certain deadlines, the timing for the election, and changes in what can be litigated before an election. Less things can be litigated now before an election, therefore shortening the timeline. As well, a major decision came out surrounding a cement company you may have seen in the news. It was a monumental decision that upended decades of labor law, in which the NLRB greatly facilitated union organizing by card check rather than the secret ballot election. In the past, if an employer was presented with union authorization cards, signed cards supposedly representing a majority of employees, the employer had the right to say, no, we want you, union, to file for an election and proceed to that election. But now the NLRB has made it such that the employer must recognize the union when presented with those cards, or generally within 2 weeks, file its own petition, which is called an RM petition, or else have to accept those cards and recognize the union. Now, the second part of that very monumental decision said that during the critical period leading up to the election, if the employer engages in certain unfair labor practices, instead of landing themselves a rerun election, as would the result be in the past, the board will order that the employer recognize and bargain with the union without that rerun election. Suffice it to say that the stakes for an employer committing ULPs, even unwittingly lesser serious ULPs, can land the employer a bargaining order having to recognize that union without the rerun election. So makes for much easier organizing. As well, the NLRB returned to what was called the Obama-era micro-unit standard. Under the Act, bargaining units have to be what is called appropriate, and that's a legal standard. And a certain decision that the board issued this year changed the standard so that unions will have an easier time organizing smaller groups of employees. And this is important because unions generally prevail the smaller the unit. And with these small fractionalized units, what we call micro units, this can create operational difficulties for the employer. An example for a real case was a department store that had, in your department store, you have the fragrance department, men's clothing, cosmetics, etc. And that decision suggested that each one of those departments within the same department store, although they had very similar terms and conditions of employment, could be separate bargaining units. All right. The NLRB also, in addition to case law, engaged in rulemaking this year on the standard for what is considered a joint employer. Due to litigation that was supposed to be taking effect in December 26th of this year, it's actually been postponed for now to February 26th. What are joint employers? They are separate entities that, because of their level of control over terms and conditions of employees' employment, are actually liable for each other's labor law obligations, such as what? Such as having potentially to have employees who are in the same unit and having to recognize and bargain with a union of those same employees in the unit. They could be liable for each other's unfair labor practices. They may be liable for each other's collective bargaining obligations. So being a joint employer is very significant. In the past, the standard under the Trump 2020 rule, it was, suffice it to say, harder for a union to prove that two entities were joint employers. Under this new standard that the board has proposed, it would be easier to prove that two entities are joint employers. Particularly vulnerable models include staffing agencies and their clients, franchise models, and enterprises that include both union and non-union entities. If you are one of those, you certainly want to take a look at your relationships and whether you could be considered a joint employer. As well, the NLRB changed the definition in a certain decision of what is an independent contractor versus an employee, such that more workers could be potentially classified as employees. And this matters because employees, unlike independent contractors, have the Section 7 rights I mentioned before, most notably the right to unionize, unlike independent contractors. So if I'm a union, I want more workers to be classified as employees than independent contractors. It is a good time, if you haven't already, to review your independent contractor relationships for compliance. I'll mention that complianceHR, the Navigator suite, includes an independent contractor assessment tool to help you do that. The overall takeaway with these new legal rules for easier organizing is that employers need to be ready for an election at any time. Even if you think the word union has never been uttered by employees at your company, the timeline is just too short. Employers should have, at a minimum, their managers educated in the NLRA. You need to be defining your company to your employees before a union defines it for you, getting your message out, and my colleagues recommend having a campaign readiness plan in place going into 2024. All right, next, the NLRB greatly expanded what is considered protected concerted activity under the Act. I mentioned that the NLRA protects union activities and organizational efforts and other concerted activity for mutual aid and protection. Now, the present administration takes a very expansive view of that. In one decision, the NLRB changed the standard to make a more permissive, employers have to be more permissive in allowing cursing, vulgarity, and potentially harassing conduct that occurs during otherwise protected activity. In another decision, the board took a very broad view of when a single employee's action can still be considered concerted, even if it wasn't actually done with the backing of other employees or obviously with other employees' consent or even known to the other employees, yet still concerted. And in another decision, the board considered employees to be engaged in protected activity when they are advocating for non-employees, such as non-employee interns or independent contractors. This was a reversal of precedent that came before it. In a decision called McLaren-McComb that you may have heard, the NLRB limited the permissible scope of confidentiality and non-disparagement provisions in separation agreements and potentially settlement agreements for non-supervisory employees. And the board said that some very common clauses actually violated the NLRA common clauses in separation and settlement agreements. And like I said, that ruling could also apply to other related employment agreements like settlements or other employer policies. We think there's no one-size-fits-all approach. There are a range of options depending on the risk tolerance of your company and other factors, and we suggest that you work with counsel to tailor agreements to the restrictions that arise out of that decision and the general counsel's interpretation of it. As well, the NLRB and the GC's approach to settlements and litigation has really raised the stakes for employers who commit ULPs. Traditionally, the remedies for unfair labor practices included reinstatement and back pay to any affected employees. But with certain decisions on the GC's agenda, the scope of remedies has expanded to other financial harms that employees may allege, such as even out-of-pocket medical expenses, penalties for missed mortgage payments, increased transportation or child care costs, and other things that we might call consequential damages. And the takeaway is that this is likely to lead to much more major economic penalties for employers and protracted compliance litigation. As well, with a major decision called Stericycle, the NLRB returned to what you may have heard called the war on handbooks. And my co-presenter Amy is going to talk about this more. But I'll say that under this decision, the board adopted a stricter new legal standard for evaluating the validity of workplace rules. No more do we have the Category 1 Boeing rules that were categorically lawful. No more of that. Rather, now rules are presumptively unlawful if they could be interpreted to limit employee rights. And we're not looking through the lens of the modern empowered employer. Rather, we're looking through the perspective of what the board describes as a vulnerable employee who is economically dependent on the employer. Policies that we know are going to be scrutinized include dress codes, also affected by another board decision this year, use of electronic equipment and no recording or camera use policies, social media policies, and rules promoting civility, courtesy, and prohibiting harassing and insubordinate workplace conduct. Employers should take the time to periodically review and assess your workplace rules for compliance. The overall takeaway here, before I move on to our next topic, is that labor law has more than ever been injected into day-to-day HR decisions. So it's very important that even if you're in a non-union workplace, you understand the labor law that impacts the workplace more than ever it does. Right. The next topic that I'm going to talk about is the changing landscape of Me Too confidentiality decisions. We all have kind of idea of what Me Too is. The Me Too trend generally was a movement that started many years ago that tried to expose sexual harassment and sexual abuses that were recurring and to prohibit the squashing and the shushing of such activity and to promote people being able to talk about them so that they would stop. The trend has been toward the unrestricted right to disclose sexual harassment, and not only that, as it began, the beginning of the movement, but also other discriminatory conduct. The National Women's Law Center says that ever since the Me Too movement went into effect in 2017, state lawmakers have worked with energy to reform workplace anti-harassment laws. 2023, they report that there were around 80 bills targeted at strengthening protections against workplace harassment, and 9 states passed meaningful protections. I'm going to focus on just a few that came out more recently and will have an impact in 2024. The first was the Speak Out Act. That's a federal law that was passed at the very end of 2022 which renders unenforceable non-disclosure and non-disparagement clauses related to allegations of sexual assault and or harassment that are entered into before the dispute arises. So if there was a company that required employees to sign non-disclosure agreements at the commencement of employment, that kind of thing would no longer be permitted. And it was understood to be aimed at preventing Me Too situations where alleged victims were restricted in their ability to come forward publicly with their allegations. Also, under Colorado's Power Act, there's a number of things for advancing the Me Too movement. It scrapped the severe and pervasive standard for harassment claims that you might be familiar with under federal and several states' laws, and lowered the standard for such claims in Colorado. It also adds multiple conditions that an employer must meet to enter into a non-disclosure agreement with employees, notably that the non-disclosure cannot cover the underlying facts of a covered claim. Employers must also comply with robust record-keeping requirements for personnel and employment-related records. Recently in New York, Bill S4516 placed greater restrictions on release agreements involving claims of discrimination, harassment, retaliation. New York had one of the original Me Too statutes. It generally prohibited employers from requiring a non-disclosure provision in a release agreement involving claims of discrimination unless such a restriction was the employee's preference. This new amendment further restricts the inclusion of liquidated damages and other provisions in settlement agreements and possibly pre-claim separation agreements. I'll note that the NLRB's McLaren decision may conflict with some state laws, like New York's, where the employee can request confidentiality. The general counsel of the NLRB doesn't seem to sync that with the McLaren decision. So that I expect that we will see the continuation of the enactment of Me Too laws in 2024. And we have a lot on deck at the NLRB, such as when it comes to non-competes, electronic monitoring, captive audience, and other issues. So much more to expect in 2024. Thank you.
Thanks, Michelle. Last up, we have Amy Mendenhall here to discuss handbook updates that you'll want to look into for the new year. Amy is a KM Director of Attorney Services at Littler and oversees a team of KM attorneys in support of all of our internal practice groups. Amy's also focused on all things handbooks, helping to support Littler's handbook practice, as well as working with our friends here at ComplianceHR and PolicySmart. Thank you, Amy, for being here. I know we're running a little late, but what can you tell us about what's coming up in 2024?
Thanks, Meghann. Yeah, I will strive to be brief here, if that's possible in the land of handbooks, but we'll just stay at a high level here. So it is an exciting and stressful season known as handbook updating season, a time when employers really take stock, look at their employee-facing policies, and try to ensure that they have updated those policies to reflect the changes from the previous year, and that they're up to date, reflecting new trends and new changes in the law that will take effect in the upcoming year. Just to give you a quick snapshot of the kind of volume of what that takes, especially on a 50-state scale, just this year in maintaining the ComplianceHR Littler handbook templates, Michael gave some stats at the top. I've added some here. We created or updated more than 45 different policy statements just in the course of the year. And you can see on the right there the states that are some of the heaviest hitters, familiar states like Illinois, New York, California, Colorado, also getting Oregon and Minnesota there in the mix, but also just a lot of states just coming in with kind of onesies, twosies, so that to achieve compliance at a 50-state level, you're really having to keep your eye everywhere. We've also have or will be removing 4 policies because laws that have sunsetted. So that includes Utah military leave and then a few different vaccine or COVID-related leaves that will expire at the end of this year. Also, just keep your eye on more than 40 different legal changes that are impacting this handbook landscape that take effect on January 1, 2024. Okay, so just quickly to dig into one specific area where we've seen a lot of kind of churn and change this year, paid leaves. And paid leaves really fall into a few different buckets. So you can think of paid sick and safe leave, mandatory paid sick and safe leave. There are also a new trend of paid family and medical leave laws, which tend to be a hybrid of a benefits, a kind of insurance benefit scheme supported by the state, paired with a leave obligation for employers. And then we have laws that say employers have to provide paid leave for any reason for which an employee wants to take leave. So kind of a mandatory PTO or vacation even law. And we've seen laws emerging in each of those three categories of paid leaves this year. So we're seeing benefits coming available in Colorado, January 1, 2024. That's one of those paid family medical leave laws. Illinois has introduced a new paid leave for any reason, mandatory paid leave for any reason law. It carves out employers who are covered by local ordinances that are in effect at the time when that Illinois paid leave law takes effect. And so that includes Chicago and Cook County. In advance of that 1/1/2024 effective date, then, Chicago really quickly introduced a new paid leave and paid sick leave ordinance that requires 40 hours of paid leave generally and 40 hours of paid sick leave. We have a new Minnesota paid sick and safe leave law taking effect, some changes in the Massachusetts paid family and medical leave, changes in Connecticut allowing leave for a mental health wellness day. That's kind of a new covered reason that we're seeing there in Connecticut, and also an expansion in California paid sick and safe leave. And I'd like to just note that many of these new leave laws do come with attendant notice and policy obligations. So, for example, in Minnesota, you are required to have the policy or a notice in your handbook. And for many of these new jurisdictions with paid leave, we see notice requirements and specific written policy requirements as well. Okay, now notice requirements, this is kind of a handbook policy adjacent area where you're ensuring that your required notices are posted or distributed in writing as well, even if it's not something that you might reflect in a policy in your handbook. So we're seeing new notices. Here's just a few examples from this year related to those captive audience meeting laws that Maureen described in New York and Maine. New York City has a new ordinance requiring distribution of materials on its Temporary Schedule Changes Act. That's a requirement that's been with us for a while, but now they've introduced this kind of notice requirement that you distribute these required materials. And then actually late breaking news, since we finalized these slides, there's been a new New York City ordinance requiring employers to provide employees with a workers' bill of rights that describes various legal protections, including the right to form a union and various discrimination protections. The agency has to release that required bill of rights, model bill of rights, by March 1, 2024, and then employers need to distribute that by July 1. So that's another new notice requirement. And then just looking at kind of who are the new kids on the block here in handbook land, looking ahead to 2024, we don't just see that long list of January 1 or March 1 effective dates looming there for us, but also we're starting to think about what might be the continued and the new trends. So here are just some new or expanded rights and entitlements and protections that came online in 2023. And we might start to see other states kind of pick up and copy these, as happens so often. So for example, in Illinois, we had expansion of bereavement leave protections. In California, that's to cover reproductive loss, which I think is something that we could in other states. California has a new workplace violence prevention requirement that employers have a workplace violence prevention plan in place. This would be distinct from your handbook and part of your injury and illness prevention plan, but again, might be referenced in the handbook or is certainly in that kind of general policy and compliance realm. We also saw expansion of blood donation leave in Illinois to now require up to 10 days of paid leave for organ donation. Leave for victims of bias crimes, that's a new one. So the expansion of the victim leave law in Oregon to include victims of bias crimes. And those are defined as crimes that are committed because of the perpetrator's perception of the victim's membership in a protected category. So again, kind of a novel protection. New York City passed discrimination protections on the basis of height and weight, a first of its kind. And there are just, as you think about that, there could be some challenges there. The law does anticipate that in some respects, and so there are exceptions for employers that might be making decisions on that basis. And there also are affirmative defenses available to employers for that one as well. And then coming in around the bend here, just some federal trends to keep in mind as you're looking at your policies. And number one, making sure they're ship-shape to reflect changes this year, and also anticipating some changes we'll see next year. And also any kind of risk and compliance challenges as you enforce and administer those policies. So Michelle talked about the new Stericycle standard. When you're looking at your handbooks, important to think about that new case-by-case analysis, that there will no longer be policies that are kind of blanket considered lawful. Instead, there's going to be this case-by-case analysis, and you're going to want to be able to articulate the business justification for that rule and ask yourself if the policy itself can convey that business justification. We're also anticipating final regulations under the Pregnant Workers Fairness Act. The proposed regulations are expansive in many respects, expanding how you define pregnancy to include, for example, menstruation and past pregnancy. They also really expand the horizon of time during which an employer may need to accommodate an employee who is not able to perform all of the essential functions of a position. So really impactful potential regulations from what we saw in the proposed regs, and it'll be very interesting and relevant for employers to see those final regs as well. And then finally, new religious accommodation standard under the Supreme Court case Groff DeJoy. Suffice it to say, this is a more onerous standard for religious accommodation claims in terms of employers needing to show the burden presented by the requested religious accommodation when denying such a request. So again, a good time to look at those policies, to think about training up managers, and to think about whether those policies are, capacious enough and introduce a kind of give and take and flexibility around religious accommodation that may be warranted under this new standard. So I think that set a land speed record, Meghann, but I'm going to wrap it up there and kick it over to you, Michael. Thank you.
Amy, thank you for that very brief but very, very dense update. A lot of information in there. Number one, thank you to all of the people that participated today. We had over 3,000 people. If you would like to sign up for a free trial and a demonstration from us to talk about your compliance, policies and how we can help you, please say yes to the poll that's in front of us right now. Thank you so much to the Littler panel of experts. As you can see, these people are on top of all the developments in legal regulation, and they're always here to help you get the right answers and figure out what you want to do. So I'll leave the poll up for a few more minutes for anyone who's interested in meeting with us. Again, thank you to the wonderful audience. Thank you to the Littler attorneys, and everyone have a wonderful and safe holiday. Thank you so much.